Welcome to Bylaws. So today is not the most exciting of presentations, but a lot of what I do isn't the most exciting except when I'm talking about pornography. So um, we're pretty much, but it's important. So hopefully it'll be interesting because it's of its importance. Okay, so this is my disclaimer. I cannot be your lawyer. I cannot give you legal advice, but I can give you information. And so that's what we're doing today. So let's talk a little bit about what bylaws are. And it was kind of interesting to me to find out that bylaws actually came from, at least the word bylaws came from the Vikings. So it's kind of amusing to me to think about all the Vikings sitting around the table with Robert's Rules of Order, but it comes from a Viking term that means town law. And as I was digging into this to find more information about bylaws, it was fascinating to me that in a lot of times the word bylaw is used interchangeably with the word ordinance, which we all know as being town laws, right? Those are the laws, the municipal laws. So I thought it was fascinating that this idea of town law, that bylaws were very analogous to ordinances. And if you think about that, that makes a lot of sense because you have statutes, you have the Constitution, you have statutes, which are legislative at the highest level. And, ordinances tend to be just kind of a small, compact group of laws that only apply to a certain particular area, right? So they only apply to a certain population. And that's what bylaws are too. And then it turns out that in the UK, the word bylaw actually is what they use in many regions to mean their ordinances. So that's probably way more information than you want to know about bylaws, but there you go. If you're ever on Jeopardy, that may be helpful to you. So at the bottom here, I have just kind of it's kind of a legal definition. So standing rules adopted by public or private corporations, societies, associations relating to their own internal organization and the conduct of their officers and members. And so those just last two lines are really important because bylaws really are kind of just the rules. They're basically a description of, right, and pretty much kind of a verification of the authority of, and then the policies of that little group. So the bylaws are just whether you're a big Fortune 500 corporation or you're a small municipal corporation or you're just a little board, that those bylaws are the rules for your members, for that population. So what are the authority to have? Anytime you make rules, you have to have some kind of authority to make rules. So why are bylaws a thing in public libraries? Why do we, why do we have them instead of something else? And there are specific authority in different library establishment laws for bylaws. So if you're a district library, under the District Library Establishment Act, there's actually a section, the section where it lists all powers of the board. It specifically says that you shall adopt it specifically says that you may adopt bylaws and regulations, right? And it says, bylaws and regulations not inconsistent with this act. So that means that your bylaws and rules have to fit within the laws of the DLEA, the District Library Establishment Act. And then those laws would govern, see, it says govern the board and the district library. So in this instance with district libraries, it seems to imply that the bylaws can govern the board and the district library, or you can have bylaws and regulations. So it kind of lays it out. It kind of gives you different options. Usually, if you look at kind of municipal law, right, bylaws generally imply the board, right? So governing the board, and regulations would generally imply the library, right? So those would be the conduct regulations for the library. Then you have under PA 164, it says the governing board shall make and adopt bylaws. So there's a difference there. So with the DLEA, you have the option, but under PA 164 libraries, you must. right? So you have to have bylaws. There's not an option there, right? And you have to adopt rules and regulations for its own guidance and the government of the library. So under PA 164, boards have to create bylaws and have to create rules and regulations for the library. Then you have county libraries. The board, it says the board shall be a body corporate and then it says a few other things, and then it says, and do any other thing necessary for the conducting of county library service. Now, body corporate simply means that it is recognized as a legal entity, right? So body corporate, you can think of like corporations, right? So it means that it has a legal face, that it's an entity that's recognized in the law as a entity that can say purchase property, that can hire people. So a body corporate just means that it's a legal entity. And so as a legal entity, it has the ability to do any other thing necessary for the library. So therefore, that gives it the option to create, since it's very broad, it gives the option to create, I would think, bylaws and rules governing that. Plus, as a corporate body, as a body corporate, it also inherently should have the ability to have rules governing its own body affairs. Now, none of the other library establishment laws mention anything about rules, but if you look at it, these three types pretty much cover all of the library establishment types that have separate boards, right? That have separate elected or appointed boards. So school public libraries, which are not here, are the school board, right? And the school board has a separate ability to have bylaws under the school laws. Then you have home rule libraries, which function as a department of the city. And the city itself, the city council, which would be its board, has the ability to have bylaws. Charter township libraries, those boards are the township supervisors or the township governance. They have their own ability to do bylaws. So these three statutes, these three different types of libraries represent the libraries that have their own independent boards. And so this gives them the authority to establish their own bylaws and their own rules. So what's the force of bylaws? Just because you can create them, right? You have the authority to create bylaws. At the end of the day, what happens if someone doesn't pay attention to them? What happens if the board creates their own bylaws but then doesn't follow them? How does the board enforce its bylaws? And so, there's this nice little quote from a legal treatise that essentially says that with ordinances, and then it mentions, like bylaws, local bylaws, ordinances. The idea is that if you're a resident of that area, so if you're a member of that board, right, then you're inherently bound by those bylaws. In other words, if you're a member of the board, if you agree and you get elected to a board, the assumption is that you know what you're getting yourself into. And so if you're elected to a board, by being elected to the board, you are agreeing to be bound by the bylaws. So that puts you under that, authority of the board. So the board has the ability to create those rules and enforce those rules and make it, keep their members adhered to those rules. And there's varying, they have different options to do that. The big question is, will they? And that gets into some issues that are a little bit beyond the scope of this particular presentation. We could spend probably a whole weekend on psychology of boards and psychology of groups and enforcement and some of the problems inherent in that and the difficulties. But essentially, the board has the right to enforce its own, laws reasonably, obviously. And we'll get a little bit more to the reasonable part in a minute. So let's talk about drafting bylaws, right? So you have the ability to have them, right? Everybody is bound by them. Let's talk about, drafting. Who puts them together? So usually bylaws are drafted as a whole piece when the body comes into being, right? So when your library was first established, your bylaws would have been drafted. If you're a library that's been, reestablished, you've turned into a district, or, you've changed from one type of library to another. You've gone from a 259 to a PA 164, for example. Chances are that you may have had some bylaws, but your bylaws may have been redone when you became a different kind of library. But there should be at one point a whole set of bylaws that were created for your library. If there aren't, then your board gets the joy of creating them from scratch. There are lots of samples out there. Hopefully you have a library attorney who, can provide you with some guidance, but we're going to kind of walk through today some of the things that should be in your bylaws. But when we talk about writing them, let's talk a little bit about criteria for writing bylaws. So it's a lot like policies, right? Your bylaws, there's a lot of legal authority that says, bylaws obviously have to be legal, right? You can't, even though you have to kind of think of it like it's just a smaller version of state laws versus federal laws, right? Or municipal laws versus state laws. So you can't have a local law that's in conflict with the broader law. And we actually saw that recently with the governor's EOs being turned over, right? Because the allegation was that the law she relied on was unconstitutional. So even though, on its face, the law might seem perfectly fine and reasonable, if it's conflicting with a higher authority, or even conflicting with other laws within the same jurisdiction, then you could have a problem. So when you're looking at your bylaws, and this particularly can be an issue with when you start drafting policies for behavior and stuff of your trustees, or policies for, say, how they're elected, how your trustees are appointed if you have a vacancy. You have to look at not only the state laws that dictate how things are done, but you have to look at your local municipal ordinances too, to make sure that there aren't any rules, whether it's nepotism or whether your local a municipality may have an ethics ordinance that could apply. Your local municipality may have some kind of term limits. And if you're not a district library, so if you're a municipal library, you're going to have to, look at that. If you are a district library, there may be multiple municipalities you might want to take a look at. And then if you do see some kind of snag, you would want to check with your attorney. So the next thing you have to look at would be due process. Okay, you need to, in addition to making sure that your bylaws, don't contrast with any existing statutes or, of course, the constitutions. You want to make sure that there is some due process there, especially with regards to policies. In other words, that they're written somewhere that your members have clear access to. And that there's an appeals process, so that if someone feels like they're called to on the carpet for violating a bylaw and they feel like that's not appropriate, that they have a way to dispute it. You need to make sure that the language is reasonable. Now, what's reasonable? Well, in a legal sense, reasonable means what any common man, right? So quote unquote common man, man being any of us, would consider reasonable, right? So it's kind of a subjective scale, but it pretty much means, if you're the one drafting it, and to you, in your, obviously, if it's not an attorney, it would be someone on the board drafting this. And if to you, it's reasonable in the context of your community and in context of your board, then chances are it's probably reasonable. If you have a question about what's reasonable, or someone else in your group in passing it questions the reasonableness, then that would be a good thing to go to your attorney with. But usually whenever you see the word reasonable in relation to a legal matter, it pretty much means what the average person feels would be, make sense. And then you need to make sure they're clear. Obviously, you want the wording, especially as we've seen over the past few months, looking at some of these executive orders and even the MDHS order and the MIOSHA emergency rules, that a lot of times you can write out a law or a regulation and it is not clear, especially if you do it by group. right? If everybody puts in their own kind of point of view, the end result can be, it's like that fable about, the blind men that built the elephant, right? Or that, described an elephant. The end result can be very different from what the intention is, or what each person thinks it is. So it's really important that your wording is very clear and that it conveys, it not only is easy to understand from the perspective of the person who has to follow it, but that it accurately conveys your goal. Okay, it accurately, designates or accurately conveys your goal of what you're trying to accomplish by that bylaw. What is the end result? What is it that you're trying to either prevent, or what is it that you're either trying to have happen? And of course, it has to be enforceable, right? You can say, well, everybody has to be, seated, with their straight backed and their, knees together. But, that's difficult to enforce, right? So you want to have a law that is, or a regulation or a bylaw that's enforceable, because if it's not enforceable, then, it's kind of on the outskirts of not being, possibly not being legal, but it's also there's no point to it, right? It has no teeth. If you can't enforce a particular bylaw or a particular policy that you're trying to put in, then there's no point to putting it in there. Okay, so now let's get to the point of bylaws, right? So we did talk about that they're, regulations, they're designed to govern the behavior, and there are a couple other things. Bylaws also serve as one of the organizational documents of your entity, right? So if you're a corporation, if you look at, again, like a Fortune 500 company, a bylaw is, along with their articles of incorporation, and any, documents they have to file, forms they have to file with the state. It is the bylaws are one of their organizational documents. So all those documents together are proof of their legal status. So with libraries, it is also one of your organizational documents, particularly if you are one of those libraries, like the PA 164 libraries, that require that you have to have bylaws. So in addition to your establishment documents, whatever documents you have as part of your establishment, which may be something as, just a ballot, result, or resolution, or if you're district library agreement, the bylaws would be another organizational document. So proof that you legitimately exist. It also serves as the listing of, your member and your officer job descriptions, as well as criteria, how they get elected, how they get chosen if you have a vacancy, what their authority is and what their responsibilities are, and then what officers do you have internally, and how do you elect them, and what are the duties and the limits of each of those particular positions. Then as we said, it's your self-governing rules and standards and policies. And then it's also usually your procedural guide for your meetings, right? Now, you may have, Robert's rules, or you may have, the other one, which Sturgis, that's the other one. There's Sturgis, and there's Robert's rules. But this, your bylaws should at least have, say, the format of your meetings, how your meetings generally get formatted. Now, bylaws can be as detailed, or they can be, more broad. There's only a few things that absolutely have to be in the bylaws, right? So you have to have, as part of your organizational document, you have to have the name of your library, what kind of establishment type you are, what the statute is that you were formed under, where you're located, your city, your county, the state, what the mission and the purpose of the library is, and then where the authority of the board comes from, right? So what is your governing, or your are you a governing board or an advisory board? What's your statutory authority? And because most library establishment types have an exact section of a statute that lists their powers. And yeah, so that's pretty much it. Just pretty much is your, here's who we are, here's why we are, here's our address, and here's, what the law says we're able to do, and essentially what we can be. Then, as far as your members section, you want to list what is the structure of the board, right? So how many board members do you have? And that's usually at least guided by statute, if not specifically dictated. A lot of libraries have options, and especially if you're a district library. How is your board seated? Is it an elected board, or is it an advisory? Is it an appointed board? What are the qualifications? These are very often put in statute. So it may say that you have to be a resident, may say you have to be an elector. How are new members recruited, right? So are you, when you have, when members leaving and you have a vacant seat, how do you recruit those? Right? So is that done with the director? Is it done through the municipality? When does a vacancy occur? What constitutes a vacancy? And that also is very often in the statute. Then now I say how a vacancy is filled. So what is the procedure? So it's not just how you recruit, how you find someone to possibly be in that seat. From the procedural standpoint, how is a vacancy filled? In some instances, depending on your establishment type, the board has the authority to appoint a provisional member until the next election. In other instances, especially with appointed boards, you would get a new member appointed by your municipality. If you have an appointed board, how does that appointment process occur? I have found that some libraries know how it works, some boards know how it works, some boards don't. If you don't know how it works, you may want to check in with your municipal authority and find out, how do you do your appointing? Is it just anybody who calls you and says they want to do it? Some municipalities keep applications, some make you fill out a form. How does your municipality, different municipalities do it? And that's good information to have. And then do any limits apply? So do you have local laws that say, again, it might have a nepotism policy? Do you have a district library agreement that says that if you have for example, a township that crosses, a city that's in a township, and each of those municipalities is on the district, how do you choose members? If you have a county that's part of your district, and you have townships in the same county as part of your district, can someone in the county be a county representative and a township representative? So there may be certain limitations that municipalities agreed to that are in addition to what is in the statute. How can a member be removed? Can a member be removed? In the District Library Establishment Act, the only way, regardless of how they get seated, whether they're appointed, whether they're elected, the only way a board member can be removed is by the governor. And that's a process that's kind of almost like a court proceeding. So it's very lengthy. But in other situations, there may be some other options. So, that's something that, depending on your establishment type and your situation, you may want to make sure that your members understand. And then you want to have a list of what does a member do? What is the expectation of a board member? What is it that they do? What is the purpose of the board in relation to the library? What are the powers of the board in relation to the library? What's the hierarchy within the board? Is there a hierarchy? What is the kind of the organizational structure of the library? You have the board, which is the boss, and then you have the director, and then you have the staff. What are the duties and responsibilities of the board members? And I don't mean the officers here, I just mean your general board members. There are statutory duties, things like their fiduciary, everybody's a fiduciary duty. There are some responsibilities regarding conflict of interest. There are some ethical responsibilities depending on your locality. You may have, as I mentioned before, you may have local ordinances that put even more ethical restrictions in place. There's some statutory duties with, yeah, I guess conflict of interest is what I'm thinking of. So then expectations. What is the institution's expectations as far as a board member goes? So for example, is the expectation that the board's going to adhere to the policies and procedures in this bylaws, and for their different duties and descriptions, what is it that the institution would expect of a general board member? And then you have officers, right? So you have, what kind of officers do you have? Do you have, not every board has, a president, a vice president, a secretary, a member at large. It depends on the size of the board. It depends on the size of the organization or the institution. So it's up to the institution and to the board, I guess the first board, or it's up to later boards to amend it, to determine, what officers do you want to have? And then how are those officers elected? What are their terms? Are there term limits? Can you have, someone be the president of the board for 40 years? Or do you say, well, you can be the president of the board 5 times and that's it? Do you say you can be president of the board 3 times in 5 years? There's different things that you can do depending on what the board feels is right for their or institution. What are the qualifications? Do you have to be on the board for a certain amount of time before you can be president? So that's, do you have to work your way through the ranks? Do you have to start as a secretary and then you go to treasurer and then you go to vice president and president? There's different, there can be different paths, again, depending on the institution. What are the voting requirements for to elect officers? Do you have to have 3/4 of the members of the board to elect officers, or is it just a majority? Then how can you remove officers? Now, I'm not talking about removing members, right? I'm talking about just removing officers. So if you have a president or a vice president or a treasurer, say, who, maybe is just not up to the job, or there may be some kind of issue, can that person be, taken out of office? And what's the criteria for that? And what's the process for that? Then you have the individual description of authority and duties for each of those offices. And again, this varies from library to library. Some libraries have very strong board presidents who have a lot of authority and who can wield a lot of power. Some don't. So it really depends, again, on your institution and what your institution feels is best for you. There's pluses and minuses for all of this, right? There's, sometimes it works really well to have a very strong president. If you have an area where maybe it's hard to get board members, or you have a situation where you're very flung out and sometimes it's not easy to get boards together for a meeting, then that may be a reason to vest a little more authority within a president to act, maybe a little more unilaterally on certain things. But that's something, again, might be good to talk with your lawyer about to see what might be a best practice. You want to make sure the descriptions of the authority are very clear and unambiguous. What can the president do? What are the limits of their authority, right? What can they do without consulting the other board members? Because one of the very important things about a board, and should be, one of the things that is put in the policies and the expectations, is acting unilaterally, right? So a board, by definition, is a group, right? So the statutes don't say that, it's a governing individuals. No, it's governing board. It's a one body, and that one body is supposed to act as a unit. So that implies that the majority of decisions should not be made by 3 board members or by 2 board members or by the board president. It means that the decision should be made as a group. And so it should be very clear in your description of what your officers can do, of what their responsibilities are and what their limits are. Okay, so that's for each individual. You know, what is the treasurer supposed to do? What is the president able to do? What is the vice president able to do? You know, depending on how many you have. So then we have the general rules and policies for conduct, right? And again, this is for the board, not for the library, not for the patrons. This is just for the board. And again, this can be as detailed or as, you know, some boards' bylaws are very sparse. Some boards' bylaws are very, very complete. One of the things you want to be careful of is that the board bylaws are not the library policies, right? So what's in the bylaws are things that only apply to the board. It's not your general library policies, okay? And that's important because bylaws are amended according to a specific process. And sometimes that specific process is not very quick. Whereas library policies, you know, patron policies, there's a huge argument to make that a little bit more flexible and agile, so that, say, the director or the board can change them as they need to change them, with not quite as much bureaucracy as it would be to change a bylaw. So it's really important. You want to keep bylaws, by definition, are just the rules that govern the board themselves, not the library. That's a separate thing. So again, your statutory limitations of board members, right? The conflict of interest, any privacy requirements, again, the privacy law, and you know, what information do they have access to, what information do they not have access to, and their duty to keep that information confidential. Their fiduciary duty. Now, this is mentioned earlier, but this is something that bears mentioning more than once. When you get more specifically into fiduciary duty in policies, what are the financial requirements of you know, being a board member? What is it that the board does with regards to finances? And then what kind of reporting do they have? What is the bylaw amendment process, right? So how do you amend the bylaws? Can your board bypass the bylaws with a certain vote? You know, that's a thing. There are like suspension of the rules you might hear of, like in Congress or in the legislature. Can you suspend the bylaws for a particular reason? If a situation comes up, maybe it has to do with filling a vacancy. You know, maybe there's some issue that comes up that, you know, you're unable to follow the appropriate process. Is there a circumstance when the bylaws can be bypassed or suspended, and who has the ability to do that, and what is the process by which you do that? What are the consequences of an infraction of the bylaws, right? So this kind of goes back to authority and enforcement. If a member does not adhere to the bylaws, what are the consequences? Is it a censure process? Since we know, for example, with a district library agreement, a board member can't be kicked out. They can't be removed, except under the most like egregious procedure, like dereliction of duty or misconduct or negligence. Now, each of those legal terms has specific definitions, but if you have a board member who's wantonly flouting all the rules and, for example, is never showing up to meetings, is maybe, you know, wreaking havoc with the staff, or, you know, if there's just a litany of things that are occurring and it's getting to the point where they're really affecting the operation of the library, then you probably have a situation where you could get that on its way to the governor. But again, that's a very lengthy, tedious process. Now, it may possibly be the case that, depending on the person involved, that just the idea that that process is being started is enough to encourage that person to resign, right? Because a member can resign. So, sometimes by going to the member as a group, in a board meeting and saying, okay, you follow your process for the infractions, you give a notice, you give a warning, you give a notice, and then you could have even a hearing. And if it's in your procedures, and you say, okay, this is everything that, we see has been happening. Here's our evidence. And then that person has a chance to respond. And then the group could say, okay, you know what, we've decided we're going to send this to the governor. And of course, I would probably get your attorney involved. And they may say, unless you agree to resign. And then they may say, I'll resign in order to avoid embarrassment or, that everything that comes with that particular allegation. They may also say, well, go ahead. But, it's like anything else, it's a process. So it's important that you have some kind of process, because if you have all these rules and you have policies and you have nothing in your documents that say how you're going to enforce these policies, then, again, you may as well not really have them, right? Because how are you going to enforce them except the most basic things? Attendance. Are you going to have you have attendance requirements? Is your board required to attend a certain amount of meetings? The statutes don't say that a board member has to attend. It is kind of inherent in the idea of the fact that the governing board, that the members have to show up to meetings. If you have an attendance policy that says you can't miss more than 3 meetings, then you want to make sure that policy is laid out and clarified. Is there someone keeping track? Is there a process for saying you're not going to be at a meeting, like you have at work or like you had at school where you have to call in? Do members have to be prepared? Do you have a policy that requires members to be prepared for meetings, that they have to read their packet? And then what about participation, either in meetings or in the library? Can members be friends? Can members be officers in the friends group, which is not a good idea? What about library operations? Can board members volunteer at the library? Can board members have any input in day-to-day operations? Can board members interact with staff? How do they interact with staff? What are the rules or policies that the board wants to put in place with regards to how board members interact with staff? What about their behavior? Discretion, we talked about privacy, but there's also discretion about if there is a disagreement on the board, right? The expectation should be that the board is not going to go off and, stir the pot by, gossiping, and they're not going to take the board business, everything's done in open meeting, right? But if you have, say, 2 board members that don't get along and there's, some tension there, or there is some, for lack of a better word, some harkening back to high school activities going on where people are upset with each other, no one wants to take that, to the staff or, to your neighbor, or especially if you're in a small town. So again, discretion. But of course, discretion, let me be clear here. Discretion is more about the board being a unified group, and not one member or 2 members denigrating a decision of the board, or calling into question because something they wanted to do didn't get done, or because they don't like somebody. I'm not talking about like illegal activity, or if you have a board that's not following the rules. That, of course, the whistle should be blown. Civility, there should be some kind of expectation that your members, particularly in a meeting, are going to behave themselves. If it's okay if they don't agree, but there's not going to be, open shouting and personal insults. Perks. To what extent does your board get to do things that maybe regular patrons can't, right? Does your board get to have different due dates? Do they get access to materials earlier than maybe some members of the public do? Do they get use of the meeting room under different circumstances? If they get anything different than what the patron policies say, then that's something you probably want to make sure is clear, and again, what the limits of that are. What are the unilateral actions? Can they make any unilateral actions? Can a board member do something on their own? If they can, what can they? And those should be very limited. Who can call the attorney, right? And this is something that's kind of important because I actually, Ann Suring and I have talked about this. If you are having an issue in your library and you have board member number 1 call the attorney, then the attorney's going to charge you for the time, right? Most often. And then you have board member number 2 call the attorney because either they still don't understand or they didn't quite agree with what board member number 1 said. Then now you're going to get charged again. So it's really important that there's some kind of understanding as to who gets to call the attorney in order to mitigate your costs. And then, of course, again, we have all the financial stuff, budgeting rules, purchasing, are you going to bid stuff out? And again, it's a fine line between putting too much in and not enough in. And I would say one of the things you want to look at, again, these are just from the board's perspective, not the library's perspective. You want to look at, how often are you going to change these? Because any rule that you think might be changed a lot, you probably don't want in your bylaws, as I mentioned. Committees, who can be a spokesperson, right? As I mentioned, who gets to talk to the attorney? Media, if there's something that happens at the library, either good or bad, who talks to the reporter? It's probably not a good idea to have everyone talk to the reporter. Have a designated spokesperson who may be the director, but you want to make sure you have a designated spokesperson, and then everyone else has to understand that that person is the spokesperson and no one else should be talking to the media. Same with social media. If any of you attended Ann's presentation yesterday as part of the MLA on social media law, that was an awesome presentation, and it's very important that you have social media policies. Now, there's social media policy for the library, which I would not put in your bylaws, but the board should probably have its own social media policy for its members, right? So what is the board permitted to do with regard to social media? There's been instances of board members using the library social media to promote their own businesses, and that's probably not a great idea. Fundraising. Does the board do any fundraising? And what are the limits there? Friends. Are you going to have a memorandum of understanding with the friends? Right? So this isn't about the boards being on the friends. This is about the board as a group interacting with the friends as a group. So it's the two bodies interacting with each other. Because remember, the friends are a separate corporation. Friends are not part of the library and are not under the same governing umbrella. Training and professional development. Are you going to require training of your members? What training do they have to do? You don't have to necessarily be specific here, but maybe you say you're required to attend an orientation. Then boards have an appeals role, right? So boards, in addition, and if you've ever gone to a policy, library policy presentation, you may see that, boards have a function as an appellate body, right? So if a patron has an infraction of a library policy, and then they're not happy with whatever the director or the library staff determine is appropriate, then they should have the ability to go to the board and appeal it. Same thing with employees, right? Employees, if an employee is disgruntled and they go through their supervisor and they go through the director and they're still not happy, they should have the ability, right, to appeal. And then there's the FOIA, whatever your FOIA policy is. At the end of the day, if someone is not happy that their FOIA request was rejected, they should have the ability to appeal to the board. So the board should have some kind of process in place that acknowledges its role as an appellate body, right, to ensure due process, and that protects not only the board, but it protects the people who are appealing as well. And then the board's authority with regard to library records. Who has access to personnel files? In theory, every member of the board has access to the personnel records. The board is the boss. But in practice, someone really shouldn't be going into personnel records unless they need to. So, for example, if you're working on the benefits of the staff, medical benefits, then that might be a reason to go into personnel records to get information on, age in order to answer questions that the insurance company may ask when they're trying to set up a policy for you. And then patron records, this is kind of the big no-no. Who has access to patron records? Is there at any point a reason why a board member would need access to patron records? If, whatever that answer is, that needs to be made clear to the board member. So, everybody just wants to do stuff for the library, right? And boards are very often people who are very proactive and very engaged in the library, but maybe they should know if, they should be walking behind the desk and checking out their own books or whatever. So it's important that they understand what the rules are there. Now, meetings, your meeting policy. So what is your meeting format? What parliamentary procedure are you following? How often do you meet? When do you meet? Where do you meet? What is a quorum? So recently I've been getting questions about a quorum, right? What is a quorum? Well, your quorum should be in your bylaws. The definition of a quorum for your particular library should be in the bylaws. There is a legal default in Michigan, which is a quorum is the majority of the number of board members you're supposed to have, right? But there are situations where some bodies have the majority of members actually seated, which would be the majority of members. Like if you have a vacancy, the quorum would not take into account that vacancy. So you want to consult your attorney and you want to make sure that your bylaws establish the type of quorum that you think is best for your particular library. What happens when a quorum isn't met at a meeting? Do you cancel the meeting? Do you continue the meeting as an informational session? What is in your agenda? Who does the agenda, right? Who does the board packet? Who does the agenda? Does the director do the agenda? Does the secretary do the agenda? How does voting work in your meeting? What if there's a tie? Some libraries have even number of board members. What happens if there's a tie? At what point should you abstain or recuse yourself? And what is the process for that? And then when is there a roll call vote versus when is there just the voice vote aye? What is your motion procedure? And then, of course, Open Meetings Act. Who does the meeting notice? Who takes the minutes? What do you want in the minutes? Most minutes, there are statutory limits to minutes. And I just did a little bit. Everyone's going to be repeating that now. At least I am. When I say statutory limits, I mean that the statute of the Open Meetings Act lists certain things that have to be in the minutes, right? So you have like who is there, what decisions were made, but as far as detail, that's up to the board. So what level of detail does your board want in the minutes? Where are the minutes kept, right? Are they online? Are they only kept in hard copy at the library? They have to be in a place that is available for people, right? Available for the public to view. Then who takes the minutes? Are the minutes taken by the secretary, which a lot of times isn't recommended, because if the secretary is taking the minutes, then the secretary can't really pay attention to what's going on in the meeting. So do you have a staff member do it? If you have a staff member do it, you should be paying the staff member. So, again, that's information that should be in there. What are your rules for public participation? This is really important. Do you want the public to give you their names and contact information only for speaking, right? You cannot ask the public for their information just to attend the meeting. But if you have people who actually want to address the board, are you going to have a sign-up sheet? Are you going to have, just take their names or names and address? How long can they speak for? Because you can limit the amount of time they speak for. You can't limit what they talk about, but you can limit the amount of time that they speak. What about virtual participation? Under the new rules, what are the circumstances under which that you can virtually participate? After December 2020, there are some limitations there. Well, you might need some policy to say, when does that kick in? And who's responsible for notifying everybody that it's going to be virtual because we have an emergency order in our area? area, or we're a district library and this area is under an emergency order, but our area isn't. So we're going to be physical, but this member has to attend virtually. How does that member let you know? You know, whose responsibility is it to keep track of whether or not an area is under an emergency order, or that there is a medical condition, or that the person is on military leave, the different options available for when someone can attend virtually. Is there a format that the board wants to make the official format? Are you going to require Zoom or FaceTime or Facebook Live or whatever the platform is? So those are things that might be good to put in there. Then the director, right? And this is something you don't see in very many, you see in some bylaws. So what is, you know, the board has the statutory authority to hire the director. All of a library's powers, right? So all of the authority in running a library is statutorily vested in the board, right? There's no statutory authority for a director. There is the board has the ability to hire a director, and in some cases they have to hire a director, and in some cases it says director and their assistants. But there's nothing in the statutes that say what the director's authority is or what the director has to do. So it's totally up to the board to determine what the director's role is and how much authority a director has, right? Regardless of the tradition of the library, of what's always been done before, ultimately, it's up to the board to decide that. So by having it in your bylaws, it's enshrined, right? And in order to change it, the board would then have to amend the bylaws. And again, I'm not saying to put too much detail in this, because too much detail could be a very big pain for changing it. And this is something that probably may need to be fluid for the benefit of the director. But there should be, what are the delegated powers that the board is giving to the director, right? For example, can the director bind the library in an agreement? Can the director bind the library in a contract? Because if there's no express authority by the board that the director has the authority to bind the library, then directors can't sign contracts for anything. Directors, you know, can't do anything that's going to put the library in a situation where the library has to provide something, right? Or the library's on the hook for anything. So this is kind of a really important one, and it can be done with a motion in a meeting. And written in the bylaws that the board intends for the director to be able to bind the library in a contract, and they can limit what kind of contracts if they want. Can the director do a contract with a neighboring municipality for service? Can the director sign that? Right now, you know, if we get contracts, we look, and if only the director signed it, we send them back, because legally the board is the one that has the power to do that. Can the director speak for the library? Again, what happens if a member of the press calls? And again, that goes back to spokesperson. Is the board the only spokesperson, or is the director a spokesperson? What about, and same thing with negotiations for things like products or you know, contract negotiations with either vendors. Can the director say, look, we're going to do this or we're going to walk? Because the director wants to know the board will have their backs. What is the supervisory authority of the director over the staff? Again, these are things that, you know, are generally accepted, which is good, but for the protection of the director particularly, you know, if it's in the bylaws that the board is delegating the authority to supervise the staff, and, you know, supervisory is not only just watch them, but it's also disciplining, then that, you know, is very clear. It makes it very clear that this director is the boss of the staff. So if you have a board member that tries to interfere with that, because either they're not paying attention or they don't know or they're disregarding this rule, then that makes it easier to deal with that, in theory, of course, with that particular board member. What is the director's role or relationship to the board, right? The board is the director's boss, but the board, it should also be a partnership, right? So the director should feel confident to go to the board whenever they need to, for, you know, to consult with them, so that it can be helpful to what is the role or the relationship of the board to the director. What is the supervisory policies of the board to the director, right? So how does the board communicate to the director? Can each individual board member communicate to the director? Can they communicate whenever they want? Can they communicate on any device that they want? Can they communicate to the director at midnight on the director's own cell phone? And if they can, you know, is it, you know, emergency only? You know, can 5 different board members decide that they want to tell the director each different things throughout the weekend? You know, there's ways to, you know, not to get so nitty gritty, but there's ways to have some broader policies to say, you know, the director works between this time and this time, or even just to say the director, you know, you don't call the director on the personal cell phone unless ABC. You could have, you know, if the director is to be contacted off hours, you know, the president will contact, you know, you could have different kinds of rules. Now, some of this depends, again, individual libraries, right? If you have a very small library, this might be more cumbersome than if you have a really big library with a really big board. You know, there's some different, you know, it's different. It's also the culture of your library. But again, these are some things that can offer protection to the director. What about the evaluation process? Maybe that should be listed in the bylaw policies, like, okay, the director is going to get evaluated every year. The director, when the director is first hired, the director gets evaluated every 6 months, whatever the board thinks is appropriate. And then what is the procedure for evaluation? How is that evaluation accomplished? Is it done through a form? Is it done through interviews? And then, you know, again, same thing with the hiring procedure. And again, the hiring procedure should be very broad. You know, it doesn't have to be, you know, probably I would say pretty much to just an explanation that the board as a whole would deal with the hiring procedure, as opposed to, or if you have a committee, a personnel committee. Okay, so let's talk about some final tips to kind of pull a lot of this together. First of all, again, as with everything that you do, as a board does, and as the library does as a government body, you want to be transparent, right? So one of the biggest, with all of problems I see with boards, one of the biggest issues I see is transparency. Is, you know, boards, not, I don't think it's because people are trying to be like sneaky. I think a lot of times it's fear, right? So people get nervous, boards get nervous that the community is going to get upset, or the staff's going to get upset, or, you know, but just the more communication that the board puts out there, the more information that is available, it actually, the opposite happens, right? So people get less stressed out. The more information, particularly staff and directors, the more information that's out there, the better off that everything is. And that's okay. You're going to make mistakes, and that's okay. But the more that you put out there, the better. If you're going to be drafting bylaws, do your homework, right? Review samples. If you're going to be amending your bylaws, view some samples of amendments, like search some other libraries to see. Many libraries have their bylaws on their web pages. Not all of them, but many do. Contact, you know, ask, if you're a board member, ask your director to find some samples. If you're a director, reach out to some of your friends. Can I see samples of what you have in your bylaws? United for Libraries has some samples. I have some samples, so you can ask me, or you can try United for Libraries. Just get an idea of how different amendments are worded, right? And how additions are worded. Because remember, the language really counts. Consult your lawyer. because again, a lot of the lawyers who work in library law have a lot of experience, and they know how to word these things to not only protect the board and the library, but to make it very clear. And then your bylaws are a living document, right? If you're a library that has bylaws that either the director has never fully read or your current board has never fully read, I've actually come in contact with boards that have never even seen their bylaws. Or if your bylaws are mimeographed or Xeroxed, it's probably time to take a look at them, right? Bylaws are a living document. You want to review them regularly. I would say anytime your board turns over, you want to review your bylaws. You don't want to change your bylaws on a whim, right? But you want to constantly keep an eye on them. You want to, because anytime something like right now with the pandemic, right? That's brought up a lot of questions about, well, who has the ability to close and open the library? Right? Who can is only the board able to close and open the library? Can the director close and open the library at their own discretion? What about meetings? Who can cancel board meetings? Who can call a board meeting? So, is only the director able to call an emergency meeting, or can anyone on the board call an emergency meeting? So there's some, what about, those of you that have Anne's pandemic plan, where it says it vests the director with the ability to make changes on the fly? That's awesome. But maybe that's something that in the future should maybe be part of the director's regular expectations. It depends on the board. So it's, you want to make sure that your bylaws are, that you keep an eye on them, and so that you curate them so that they're always exactly what the board intends, and they're not these old things that nobody pays attention to anymore. If you have policies that are too changing, the more flexible your policies are, the less they should probably be in the bylaws, or just put a very broad explanation in the bylaws. Because again, the bylaw process in most instances, the board decides how to amend their bylaws. But a lot of times the process to amend bylaws is more complicated than just amending a general policy. So that's why, you want to make a distinction between, how much you want to put in your bylaws and how much you're going to just keep as separate policies. One thing to really focus on is that the bylaws are just for the board. And stand by your bylaws, right? If you're going to put all that work into them, follow them. And as fellow board members, encourage them to follow them, and then enforce them as a group. Don't leave it all to the board president to be the bad guy, because that will not work. Nobody wants to be the bad guy. And as a rule, all of us hate conflict. And we don't want to be the one who points a finger and says, hey, you've been absent 3 times. While a lot of times it is the board president's job to rein in kind of rogue members, that doesn't mean that the rest of the board can't have their back and you vote as a group, right? Don't leave, your one member out hanging who's enforcing the rules, right? Enforce them uniformly and enforce them as a group, because peer pressure is one of the best forms of enforcement, right? So those are my tips for bylaws. As I mentioned, I have some samples. I see that there is some questions in there. The slides will be sent to you. Becky has offered to help me to make sure things get out quickly, and so I very much thank her for that. So between her and I, those will go out shortly. And there also will be an evaluation. I see that someone put it in the chat there. If you would please take that, I'd appreciate it. And if you could please put a little note in there for me if you have any suggestions for future webinars, because I do one every month, and I would really, be happy to do one that people are interested in, that think on topics that people are hopeful, would like to have one on. And any questions that I can see in the chat, I'll address, so that they can go in a emailed to you. So thank you very much for attending. I very much appreciate it.